So I recommend people go online, U.S. Supreme Court, and look up Hogan versus Mississippi.
Okay. And do you know when that decision was handed down?
Oh, it was a while ago. Let me think. I think it was in the late 50s.
Okay. Okay. So that's Hogan, Hogan versus Mississippi.
Right, and it's good law, but it just hasn't been applied to divorce courts, and that's the last thing they want, because they are violating the Constitution. I'm convinced. There's no question about it. And once, if I were to get my discovery, which is what I was asking the district court for, let's go in their files and see what the percentage is. And then how is the state going to explain 90% to mom, 10% to dad, as far as child custody, physical custody?
Now, did they turn any of that over to you at all, or?
No, I was booted out eventually of Fourth Circuit. They said, no, we don't think we want to give you any of that. So at this time, I am in the Ninth Circuit of Appeals Court in San Francisco, and they're looking at the Fourth District decision. Okay,
so again, for our listeners who don't quite understand the way the court system works, the district court is a lower level of the federal court system, and he has now appealed that to the Court of Appeals system for the federal courts, and then of course above the Court of Appeals system would be the U.S. Supreme Court.
Correct. And it is interesting to note that I got into the Ninth Circuit of Appeals with a 3-page handwritten brief, which was rather interesting, and I'll have that on my site too. It's in there, and it didn't cost a lot of money, and it didn't take a lot of time. Right. Now, there's not always great hope, but that's the next step for me, is to go to the Ninth Circuit, and after that, if I'm not successful, I will continue to go to the Supreme Court.
Now, do you have any idea how the best interest, do you use the best interest factor in the state of California, first of all?
They have a system where a marriage family type counselor is employed by the court, and they look at the case and they meet with the parents, and then they decide where the kids should go, with mom or with dad. Okay. And that's basically all the judge looks at. They just look at the recommendations of this person that's employed by the court, and then just rubber stamps it, and that's it. You're done with.
What sort of system would you like to see employed? I mean, what sort of factors would you like to have considered, and who would you ultimately like making that decision?
I think perhaps fault divorce was a better system. It was changed back in the 70s by Governor Reagan, and he did mention that he was very upset over time that he thought that was a mistake that he made as governor. In some states, they have fault divorce, where if one party decides, hey, I'm out of here, I'm sick of you, they actually don't get special treatment. They get punished a little bit. Maybe that would be better, but certainly not 90% custody automatically to mom just because she's the mom. My child was 6 at the time, and I could have taken care of him just as well as her, yet the general feeling by the court is, well, of course the mom is better suited. And that's part of where Hogan comes in, because Hogan versus Mississippi talks a lot about that. The stereotypical views should not be enforced by the courts.
So should a judge be making the determination, do you think? I mean, you said you use, in Missouri we actually do have a judge who ultimately will make the determination, although a guardian ad litem can be appointed to represent the best interest of the child, and oftentimes their recommendation is accepted by the judge. But for all intents and purposes, it's the judge who makes that decision. Do you think that's a better system than having this third party who sort of looks at everybody and then makes that decision?
I would think the judge, in my case, did make a decision based on this recommendation, but I think the recommendations are biased. And ideally, I think whoever's got a better chance of taking care of the child should end up getting the child and not base it on, well, whoever's the mom should get the child. I mean, unless you're down in 2 and 3 and 4, I guess, but at 6 and 7 and 8, I can't get my kid, and I'm missing a lot of time with him.
What, in your opinion, what would have been a just result? I mean, how much time do you think should have been allocated to each parent in your case?
Oh, I think I should have gotten physical custody. She had no job, she had no money, she had actually caused the marriage to disintegrate. I mean, that's another matter, who's at fault. But with no fault, it kind of removes a lot of those factors.
Right. Well, I mean, in the past, I think financial or ability to care for the child was considered. That's maybe early 1900s. But at that time, things swung so much the other way because fathers tended to be the main provider for the child, and therefore fathers defaulted to get custody. And then it swang back the other way so that moms defaulted to get custody because they were considered to be a primary caretaker, or there's this tender years presumption that a child of tender years should be with their mother. So at least in Missouri, and I think in a lot of other states, they've sort of compromised with this best interest of the child standard, in which is pretty loose, and judges can consider lots of things. But from what you're saying, I gather that, in your opinion, the stereotypes, the gender discrimination against fathers has not been eradicated based upon the taking out that tender years presumption. Is that